Hello, this is Professor James Strickler, and this is a course in American government. This lesson is from Unit 9 about civil rights. It's Lesson 5 about legal challenges. In this lesson, you'll learn about the civil rights movement, about the NAACP, about Brown versus Board of Education, about Bolling versus Sharp, and about reverse incorporation. In previous lessons, you've learned about some obstacles that were put up in the way of civil rights for African Americans in the aftermath of the Civil War. One of those obstacles was public segregation. In other words, setting up a legally mandated system of people of different races enjoying different public services, for example, schools. Another obstacle was private discrimination. For example, owners of businesses saying that they would only serve people of a certain race. And the last obstacle that we've talked about in a previous lesson was voter suppression. Rules that were put in place to try to discourage Black Americans from voting despite the right to vote being granted to them by the 15th Amendment. The civil rights movement was an uprising, grassroots activism that rose up in opposition to these methods that had been used to suppress people's civil rights. While the civil rights movement uses that, what is actually a generic name, civil rights, that could be applied to other things, it's generally remembered as a name that is associated with the fight for racial equality. The civil rights movement was something that really got going in the United States of America in the decades of the 1940s, 50s, and 60s. That's when some of the most significant gains were made. One of the big players in the civil rights movement was a group called the NAACP, which stands for the National Association for the Advancement of Colored People. It was a formal organization that had been created specifically to fight for civil rights for African Americans. In the 1950s, the NAACP was pursuing a strategy to gain civil rights of challenging these efforts that were made to suppress civil rights in court. They would bring lawsuits claiming that what was being done to suppress their civil rights was in some way unconstitutional. Their first big success using this legal strategy was the United States Supreme Court case of Brown versus Board of Education. In Brown versus Board of Education, there was a group of families, a small group that had their cases consolidated in different towns around the country, who simply wanted their children to be able to attend schools that had been set aside only for white children. So these are African American families that wanted their kids to go to white schools. The lead plaintiff in the case was a father of two children who lived in Topeka, Kansas. Now, these families that were picked for these cases, now when I say picked, they were picked by the NAACP. Their lawyers were paid for by the NAACP. These families were picked because they had particular personalities and circumstances that they thought would be appealing to juries and eventually judges also in having sympathy and giving them the correct decision in the mind of the NAACP. For example, the Brown family lived in Topeka, Kansas, not what you think of as a hotbed of racism. Nonetheless, schools were segregated in Topeka, Kansas. And not only were they segregated, but they were pretty good schools for both races. Now that was actually important because they didn't want a judge to simply invoke the Plessy versus Ferguson decision and say, hey, the problem here is they can have separate facilities as long as they're not equal. As long as they are equal. But these facilities aren't equal, so that's the problem. Kansas just needs to make the black schools better and we'll be okay. They didn't want the court to be able to get out of the case that way. So they picked this family because the children were actually going to a good school, even though it was blacks only. Not only that, to get to the black school, the kids had to actually walk by the white school. So for that reason, this family could make a claim that would be one that would generate sympathy for their cause. They could say, look, our little girls walk to school. We want them just to go to the closest school to our house, which happens to be designated all white. Why? Why should they have to walk by the school closest to our house to go to a different one? That's treating them unequally. All right, so we had this group of families, that these different cases that were sponsored by the NAACP, that all their cases got consolidated together before the United States Supreme Court to decide about the constitutionality of children going to segregated schools. If the Supreme Court had simply applied the precedent from the Plessy versus Ferguson case that we learned about in the previous unit, these families would clearly lose. But that isn't what happened. The United States Supreme Court overruled the Plessy decision in Brown versus Board of Education. Now notice this is about 60 years later. Plessy was decided in 1896, and this is 1954. The Supreme Court said that in public education, separate educational facilities are inherently unequal. The reason they reached that decision is that they felt that merely separating people by race was effectively labeling one of the races unequal, inferior. And that was recognized by people. And that psychological impact was there no matter how good the schools actually were. This decision in the Brown case was then used as a precedent to eventually strike down all forms of state-required segregation, whether it be in hiring police officers or sending kids to college or whatever it is. They ended up saying that the state governments couldn't engage in creating separate facilities for people based on race, and they would cite Brown versus Board of Education as the reason for that. But notice as they render this decision in Brown based upon the Equal Protection Clause. The Equal Protection Clause that says that no state can go about treating people unequally, denying them equal protection of the laws. Think about what that doesn't cover. Now, you may immediately be thinking it doesn't cover private individuals because we talked about the state action doctrine in the previous lesson in this unit. But there's also something else that's not covered by it. That is, the national government is not covered. And not only is the national government not covered by the Equal Protection Clause of the 14th Amendment, but there is no other Equal Protection Clause in the Constitution that applies to the national government. So if you go strictly by the text of the Constitution, while states may be required to treat people equally regardless of their race, the national government is not so required. Well, at the same time that the United States Supreme Court was deciding the case of Brown versus Board of Education, they had a companion case come before them, Bolling versus Sharp. This was brought by parents who lived in the District of Columbia, where they also had segregated schools, and they wanted their children to attend white schools. Remember that the District of Columbia is not a part of any state. It's where the national government sits, Washington, D.C. It is a federal territory. It is not part of any state, so it is not covered by the 14th Amendment, which begins, no state shall. So the Equal Protection Clause of the 14th Amendment does not apply to Washington, D.C. So based on that, you would seem to think, well, gosh, I guess while they may not be able to have segregated schools in Topeka, Kansas, it appears they can have them in Washington, D.C. But when the Supreme Court considered that possibility, they simply decided that their opinion, that was unthinkable, that there was something morally wrong about telling the states they can't have segregation, but are still allowing the national government to have segregation. Well, what you should realize by this point in this course is once the Supreme Court decides they don't like something, they're going to find some way, somehow, to say it's unconstitutional. Well, in the Bolling case, what they ended up settling on is that old friend of ours that seems to be available to be used for anything, due process of law. The Supreme Court looked and said, you know what? There's a due process clause in the Fifth Amendment that applies to the national government. And in our opinion, the concepts of equal protection and due process are so close to each other that we can end up saying that some sort of discrimination of treating people unequally is bad enough that it violates due process. So essentially what they're doing is they're taking the idea of equal protection in the 14th Amendment and they're reading it into the concept of due process found in the 5th Amendment. Now, in some ways, this makes no sense because in the 14th Amendment, you have separate due process and equal protection clauses. If due process includes the idea of equal protection, then it's redundant to have these two clauses, one right after another. But regardless of whether it makes logical sense or not, the Supreme Court still decided to say that due process includes the idea of equal protection, so that they could say that the due process clause of the 5th Amendment, which does apply to the national government, includes the idea of equal protection. This very bizarre effort that the Supreme Court went through to accomplish what they consider to be the morally right goal of ending segregation by the national government has become known as reverse incorporation. Now think about why it might be called reverse incorporation. Recall what we talked about previously in the course and labeled as selective incorporation. Selective incorporation is, if you'll remember, when the courts borrow ideas from the Bill of Rights and then read them into the Due Process Clause of the 14th Amendment to thereby make states obey them also. Well, in reverse incorporation, you go the other direction. Rather than borrowing something from the Bill of Rights and reading it into the 14th Amendment, in this case, you borrow something from the 14th Amendment, the Equal Protection Clause, and then you read it into the Bill of Rights, specifically into the 5th Amendment's Due Process Clause, to then make the national government obey it. So now let's put these ideas of how civil rights are protected into this diagram that we began building in the previous unit. Now remember, in the previous unit we were talking about protecting civil liberties. So we had the bottom part of this diagram grayed out, and at the time I said, don't worry about that, we'll get to that in the next unit. Well, now let's set civil liberties aside instead, and let's actually get to talking about civil rights. Let's begin with the lower right-hand cell. Now notice we're trying to protect civil rights here, in other words, make sure people are treated equally. And then if we look to the column, we are talking about treating people equally before the state government. So what in the Constitution is going to require that state governments treat people equally? In other words, honor their civil rights. Well, that obviously is the Equal Protection Clause, which is found in the 14th Amendment. But remember, that only gets us halfway to where we want to be, because we still have the national government potentially infringing upon people's civil rights. So now let's think about what in the Constitution will stop the national government from taking away people's civil rights. Well, remember, there's nothing. There is no Equal Protection Clause in the Constitution that applies to the national government. So the national government had to come up with this idea of reverse incorporation, where they take the concept of equal protection found in the 14th Amendment and they read it into the Due Process Clause of the 5th Amendment to make the national government obey it also. In other words, to force the national government now to treat people equally, thus protecting people's civil rights against infringement by the national government. So, through the Brown case and the Bolling case, the Supreme Court has established that government segregation is completely unconstitutional. So now let's go back to our diagram for a moment, and let's think about how constitutionally the Supreme Court accomplished protecting civil liberties and civil rights against the national government in the states. First of all, if you look at the two cells here that are highlighted in yellow, these are the places where the Supreme Court used the actual text of the Constitution to accomplish the protection they wanted. The Bill of Rights is actual text that protects civil liberties against the national government. And the Equal Protection Clause in the 14th Amendment is actual text that protects civil liberties against infringement of state governments. But now if we flip it around and look at the other two cells, we see where the Supreme Court had to invent things that are not actually found in the Constitution, where they had to invent selective incorporation to force states to obey the Bill of Rights, and they had to invent reverse incorporation to force the national government to obey equal protection. These things do not exist in the Constitution. These are examples of activist courts using their powers of interpretation to rewrite, amend, create new constitutional concepts to be what we've seen in this course described as a constitutional convention in continuous session, or being the Constitution itself. That's what the courts set themselves up as they create these new constitutional concepts. Now, in the end, we may be glad about this. We may look here and say, you know what, I'm glad that states can't take away my civil liberties because the Supreme Court invented selective incorporation. Or I'm glad the national government can't take away my civil rights because the Supreme Court invented reverse incorporation. But even if we like the outcome of these things, it doesn't change the fact that it's the court just simply making these things up rather than them existing in the actual text of the Constitution. All right, that completes this lesson. Now let's review what we learned in it. First of all, what was the civil rights movement? Was it something that argued for religious freedom? Or was it something that demanded free speech? Or did it challenge racial segregation? Or did it fight gender discrimination? The civil rights movement challenged racial segregation. What was the most prominent civil rights organization during the civil rights movement? Was it the AFL-CIO, the NRA, the AARP, or the NAACP? It was the NAACP, the National Association for the Advancement of Colored People. These other things mentioned here are the AFL-CIO is a labor union, the NRA is a group that lobbies about gun rights, and the AARP is an organization of retired people. The NAACP is the civil rights organization. What did Brown versus Board of Education rule? Did it rule that education is a state issue? That separate is inherently unequal? That public education must be free? Or that separate can be equal? Brown versus Board of Education ruled that separate is inherently unequal. What idea did the Bolling case create? Was it substantive due process, selective incorporation, expressive conduct, or reverse incorporation? The Bolling versus Sharp case created the idea of reverse incorporation, which, remember, is reading the concept of equal protection found in the 14th Amendment into the Due Process Clause of the 5th Amendment to force the national government to obey equal protection also. What does reverse incorporation do? Well, I just told you. Let's see if you can remember, though. Does it tell you that states must treat people equally, that cities must treat people equally, that the national government must treat people equally, or that businesses must treat people equally? Reverse incorporation is about forcing the national government to treat people equally. All right, that finishes this lesson. The next lesson will also be from Unit 9. It'll be Lesson 6, which is about public pressure.